Hello, my name is Brian Mayer. I am a family law attorney practicing in Southern California, and today I'm going to be answering the question of who gets our children when we die. Now, I will post informational videos like this from time to time, so if you think this is interesting or informative, please consider subscribing to my channel. You can also like the video or leave comments below. That helps the video get more exposure and just get the information out there to help people. So there are really two scenarios, and they kind of play out differently. The first scenario is when the parents are separated, not living together, maybe divorced, maybe they were never married, but regardless, where they're separated. And the other scenario is where the parents are living together, and the question is more along the lines of what happens if we both die. So I'm going to answer that question first, but I will be getting to the question of separate parents. So first of all, when both parents when both parents are deceased and you have minor children, often the question is, do we get to decide where who raises our kids? What happens if we haven't made that decision? How does the process work? And the short answer is that as parents, we can make decisions related to the health and welfare of our children, and that actually continues after we're deceased if they're minor children. And what we can do is we can nominate guardians for our children. Now, a guardian, most people have kind of heard the term. What a guardian is it's basically someone who is not a parent, but they have parent-like legal authority. They have rights as it relates to physical custody, legal custody, decision-making, things like where the child goes to school, what kind of health care they receive, medical, dental decisions, those sorts of things. A guardian does all the things that a parent normally does, but they are not the legal parent of the child. They just have that power. So when both parents are deceased, what they can do is before they pass along, they can nominate a guardian. This would be someone that they choose who they believe is competent and capable and in the best position to take over that sort of parental role after both parents die. However, this is a little bit different from actually choosing the guardian. The court will assign a guardian for a minor child when the parents are deceased, but it's ultimately the court's decision. And the reason why is because, frankly, the parents are deceased and they're not there to give an up-to-date, at that moment, opinion about who should take their child. The parents, when they nominate someone, that nominee is presumptively the right person to choose for their child. But if, let's say, for example, the parents nominate Uncle Ted to be the guardian of their child when they die, and in fact both parents do die, and between the time that the parents nominate that guardian and before Uncle Ted has a chance to take over as guardian, he gets convicted on felony drug trafficking and prostitution and assault and domestic violence, and Uncle Ted is just clearly not the person who is fit to take over here. Well, despite the fact that the parents chose Uncle Ted as guardian, despite the fact that the parents nominated Uncle Ted as guardian, the court in all likelihood is not going to appoint Uncle Ted as guardian simply because he's unfit. The court will then in fact consider the choices. The preference is for the child to be placed with a close relative or someone with whom the child is already familiar, whatever is going to give the child the most stability for the situation. And the court can look at the different family members and see who's in the best position and who wants the job and who's qualified and those sorts of things and make the decision. So it's ultimately not 100% up to the parents simply because of that. Also, sometimes, occasionally, parents just make bad decisions. Maybe they already knew that Uncle Ted was this terrible choice, but they nominated him anyway. The court's not going to place the kids with Uncle Ted if he's a bad fit one way or another. the court's kind of a safety net, though, for the parents in case there is something wrong with their choice. But presumptively, if the parents want the children to be placed with someone, then they have that option. Now, let's say, for example, that the parents let's say the parents want their child placed with Aunt Jane, and Aunt Jane is in fact a terrific choice, but the kids don't really know Aunt Jane. They're much closer to mom's parents, and they really love these grandparents, and they're very close to them. And the parents name Aunt Jane. They propose Aunt Jane as their nominee for guardianship. The parents die, and now Aunt Jane is nominated to be the guardian, but the grandparents say, well, we don't think Aunt Jane should do it. We're much closer. We're in a better position to do it. They know us. There's less of we think it's best for the kids if they stay with us. In that sort of situation, assuming there's no problem with Aunt Jane, assuming that she's competent and capable, Aunt Jane will in fact be, in all likelihood, appointed as guardian of the children, simply because the parents have nominated Aunt Jane, and there's really nothing wrong with Aunt Jane. There's no affirmative reason to not have Aunt Jane appointed, except for the preference of the grandparents. The court won't get into that sort of battle as long as the nominee is capable of doing that. So for people who are thinking about family members and who want to make a good decision for where their children are placed, the first thing to do really is to ask yourself, is our nominee, is this someone who is going to be capable? Do they have a clear and appropriate background? And little things, little run-ins with the law typically won't stand in the way. If Aunt Jane had a DUI 10 years ago or something like that sort of thing won't be a factor of consideration in all likelihood. That would prohibit her from being able to be guardian for the kids. But it's really important still to nominate someone who you think would be good for the kids. And just imagine a scenario where if somebody came out of the woodwork and wanted to say terrible things about this person, what things could they say that might be true that would make them unfit? And as long as the person is capable, as long as you trust them, as long as there's no sort of objective reason that this person can't be the guardian for the child or the children, then you can pretty much assume that the nominee is going to be approved by the court to take care of your kids after you pass. So that's sort of the scenario where the parents are in agreement with each other. The other scenario that comes up fairly common is what about the situation where the parents can't agree? And in that sort of situation, or the parents are separated, or usually it's in the sort of scenario where they're divorced or they've never been together, and the question that most commonly comes up actually is oftentimes from a mother who's primary physical custodian, and maybe dad sees the kids every other weekend or something like that. It could just as easily go the other way, where dad is the primary custodian and mom, just for whatever reason, doesn't have as much contact with the child. The kids are with dad 90% of the time, or whatever the situation there. And what I most often see come up is where the primary custodian feels like the children should be placed with someone other than the other usually biological parents, and they're just worried about that, basically. And so the first thing to understand is that really when you pass, if both parents are still alive, then each parent's both have their parental rights. And although one parent's custodial rights may be superior to the other parent's custodial rights as determined by a court order, both parents have those parental rights. And the parental rights are, unless the parents are genuinely unfit, those parental rights will trump any other custodial claim, for the most part, that anyone may have to the child. So let's say you have a scenario, and I'll just, again, it can just as easily be the father as the mother in this sort of situation. But let's say you have a mother who has the kids 95% of the time. And it's not that dad doesn't love the kids or anything like that, but he just enjoys his lifestyle and enjoys being an every other Saturday sort of dad, and the kids are fine with it, mom's fine with it, dad's fine with it, whatever. He has his 5% and that works out. But they're with mom 95% of the time. And so if mom can, as discussed previously, mom can go ahead and nominate a guardian for the kids. But what's going to happen is if she passes and if the dad is still around, and assuming he wants to have custody of the kids, then the kids will in fact go into dad's full custody at that point, regardless of whether mom or not mom nominates someone else. Dad's parental rights are going to trump any nominee that mom has offered up as being qualified to take guardianship of the kids. You may feel like, okay, well, maybe dad's not that great of a guy, or my parents or my sister or my brother would be so much better for raising the kids than dad because dad's not really involved. The fact is that if dad is unfit, if the kids are not safe with dad, if dad is just not up to the task, then they can come in and they can ask for a guardianship based on dad's unfitness. But again, unless there is some sort of affirmative reason that makes dad simply unqualified and unable to take care of the kids, dad will have custody of the kids in the event of mom's death, and that is a 100% certainty. There is a relatively recent Supreme Court case called Troxel v. Granville, where the Supreme Court basically said that the parental rights are a fundamental constitutional right, and that's just the highest and greatest weight that the law can give to any right that we have, is that fundamental right. And so dad's fundamental right, assuming there's not an affirmative reason to take the kids away due to unsafeness or unfitness or something like that, the kids are going to go to dad, period. Now, let's imagine sort of a unlikely but still nonetheless possible scenario. Let's say that both mom and dad are separate, but then they both die. And this is really where nominating a guardian can still make sense in the context of it can still make sense in the context of the parents being separated, because that can happen. And so now let's say it's dad who has custody of their child 95% of the time, mom is 5%, and they both pass along. Well, if dad nominates a guardian, then and mom doesn't, then the court is going to look at dad's nomination, and the kids are probably going to end up with the nominated guardian, as discussed previously. Likewise, if mom nominates someone and dad doesn't, that's the information that the court's going to have, and it's probably going to end up with mom's nominee. If we have a situation where both mom and dad nominate a guardian, and let's say that their nominee are different people, then at that point the court really is going to have to get involved. It's going to have to look at the relationship between the nominees and the children. It probably will, to an extent, consider to what extent each parent was in a position to assess what was best for the kids. Those nominees are going to be the leading contenders, but a decision is going to have to be made by the court, and that's another reason why the parents don't get to choose outright. They get to nominate, is because things can happen where even in an intact relationship or marriage where the parents are working together, this may be the one thing that they disagree on, and they have to choose a nominee, they end up nominating different people. So the last thing to consider with all of this too, and oftentimes this comes up then, is how do you nominate someone? Well, in writing. And the laws tend to vary by state. Here in California, it's something that if you can actually just include as part of a last will and testament or as part of a living trust. It's just information that if it's out there, if it's properly included in one of those documents, and that's really the cleanest way to do it since you're preparing your estate for your death anyway. But you can just include it in those sorts of documents, and that's the most common place. But the answer is in writing. If it's handwritten, that's a great way to do it. If you type it out and have some witnesses sign, that's a way to do it. If you're dealing with the living trust, definitely talk to your attorney about that. But that's another way to do it, is included in there. But the short answer really is just in writing. And if you need details on that, then you definitely want to see an estate planning attorney or a family law attorney to help out with that. So again, this is Brian Mayer. Please consider subscribing to the channel. Please feel free to like or leave comments below. I hope that you found this helpful. If there's anything that you would like addressed in a future video, please go ahead and feel free to leave a comment below. I'll take a look at it, and it may end up in video sometime soon. Thank you so much.